On Government Order of the Day, number 5.
Coroners Amendment Bill, second reading.
Mr Speaker.
The Honourable Amy Adams.
Mr Speaker, I move that the Coroners Amendment Bill be now read a second time. I want to start by commending our 16 coroners and Chief Coroner on the excellent work that they do in New Zealand. Coroners investigate between 3,000 and 3,500 sudden deaths in New Zealand every year. Many of these involve tragic and difficult circumstances. Despite these challenges and the often intense public scrutiny that comes with the job, coroners conduct themselves with dignity and integrity. They have a critical role to play in our justice system, and they carry out those duties admirably. Mr Speaker, the Coroners Amendment Bill we're debating today will help improve the roles of our coroners, widening their powers and making their jobs easier as they carry out these important roles. The bill makes a range of improvements to the Coroners Act 2006. These reforms stem from a targeted review of the Principal Act initiated by the previous Courts Minister, my colleague the Honourable Chester Burrows. The review found that our coronial law was generally functioning well, but that amendments could be made to clarify the role of coroners, to ensure their recommendations are better focused and more relevant, and to improve the efficiency of the coronial system. The bill achieves these aims through a number of ways, and I want to touch on a number of key changes that will improve the way our coroners operate. Firstly, our changes will ensure coronial recommendations are better focused and more relevant by clearly linked to the evidence before the coroner. In making a recommendation, the coroner must show how the recommendation would have prevented the death in question. The coroner must also consult on draft recommendations with interested parties, such as families or witnesses, before finalising them. This will help ensure that coronial recommendations are more relevant and are more likely to be adopted by those to whom they're directed. I note that the Select Committee considered and rejected proposals to require those receiving coroners' recommendations to respond to them. As the quality and relevance of recommendation improves as a result of this bill, voluntary response and implementation should become more common. The committee has recommended a change to the provisions governing consultation with interested parties. If the interested party being consulted has not responded within 20 working days, the coroner will be able to assume that they have no comment to make and proceed to finalise the recommendations. This, Mr Speaker, is a positive step. It will prevent unnecessary delays and allow the coroner to proceed with their draft finding, confident that they have given affected parties an appropriate opportunity to comment on the draft recommendations. Mr Speaker, another change in the bill is to remove the need for a public inquest to be held when a death in custody is clearly unnecessary, such as from illness or old age. They will, of course, still have the ability to order an inquest in any case they feel needs investigation, and interested parties will continue to have the opportunity to request that an inquest be held. Coroners are independent judicial officers. It's important we allow them the freedom to make sensible decisions and ensure that proper oversight remains on the cases where it's needed. Between 2007 and 2013, there were about 80 deaths in official custody or care for which the Act currently required a public inquest. In nearly 60% of those cases, the cause of death was known and found to be natural causes. An inquest with a full oral hearing of evidence and witnesses is resource-intensive and time-consuming. One of the main goals of the Coroners Amendment Bill is to reduce delays in the coronial process and to ensure coronial resources are directed to where they're needed most. The bill doesn't remove the requirement for a coronial inquiry to look into the case. This will still be mandatory for deaths in official care or custody, but can proceed without an oral hearing. I know that the Chief Coroner, Judge Deborah Marshall, in her oral submission to the Select Committee, welcomed coroners having this flexibility. It's also important to note that when an interested party such as family, medical experts or witnesses asks to give evidence, an oral inquest must still be held. Together, these changes will help avoid unnecessary inquests into cases where the coroner considers the cause of death is plainly natural, while ensuring appropriate cases continue to receive necessary scrutiny. Another key change which has drawn some attention is the death of Defence Force staff in hostilities overseas. The bill specifies that coroners may not inquire into deaths overseas of New Zealand Defence Force personnel as a result of hostile action unless the Attorney-General directs an inquiry. This is a sensible and reasonable approach, and I'm pleased that the committee has recommended continuing with the bill's proposal. Coroners will still be able to investigate other Defence Force deaths, including those not resulting from hostilities or resulting from an accident or suspected suicide, both in New Zealand and overseas. Our provision simply avoids duplicate investigations of Defence combat deaths, given that these are normally investigated by the Defence Force's Court of Inquiry process. It also prevents coroners from considering matters that are not traditionally part of their jurisdiction, such as military tactics, national security, and operational decisions of military commanders in the field. The provision requiring the Attorney-General's direction is closely comparable to a similar provision in the Visiting Forces Act 2004, which requires the Attorney-General's permission before a coroner can inquire into the deaths of visiting service personnel in New Zealand. The committee has clarified the definition of hostile action and specified some criteria for the Attorney-General to consider in deciding whether to direct an inquiry, and I think these changes will be very helpful in practice. Mr. Speaker, the bill also seeks to ease and clarify New Zealand's restriction on media reporting of suicides and suspected suicides, which have been in place to prevent copycat suicides. It implements the Law Commission's recommendation in this area, which were based on considerable research and engagement with experts. Research has shown that certain kinds of media reporting, lurid, glamorising and method-specific, do tend to spur more suicides in the community, especially amongst young people. With New Zealand's unacceptably high rate of suicides, we need to be doing all we can to discourage people from taking their own life, while also preserving the freedom of speech of our media. At present, no information about a death which appears to be self-inflicted can be made public until the coronial inquiry is completed. Under our changes, if there is reasonable cause to believe that a death is suicide, the person's name, job and address, and the fact that the death is suspected to be self-inflicted can be made public. Once the coroner finishes their inquiry and finds a death suicide, the death can be reported as suicide. Some may want us to go further and permit all and any details surrounding the death to be published. But I don't want to see the situation in New Zealand that exists overseas, when newspapers regularly report suicides in ways that may be likely to be harmful, including publishing photos of sites and gruesome, detailed descriptions of the methods used. Mr. Speaker, we've worked hard to ensure the bill strikes a difficult but careful balance between the useful role positive conversations around mental ill health can have, while minimising the risk of copycat behaviour. The Chief Coroner will also be able to grant an exemption from any restrictions that the bill proposes to retain. A new expert panel convened by the Director-General of Health will be able to assist the Chief Coroner in deciding these exemptions. Mr. Speaker, the Coroner's Amendment Bill will improve the coronial system by making it more efficient and more responsive to the needs of families. I want to thank the Justice and Electoral Select Committee for its consideration and for the amendments the committee has put forward in its report. The proposed changes are well considered and will help the bill to achieve its goals. This bill builds on the major overhaul of the coronial system introduced by the Coroners Act 2006. Its proposals are practical, well considered and generally well supported by submitters. Mr. Speaker, I commend the bill to the House.
Members, the question is that the motion be agreed to.